We are live.
Good morning. This is Senate and House Judiciary Committees meeting. Our topic is the court backlog. I'm sure a lot of you have heard from constituents and others about the backlog, and this is not an attempt to point fingers at anybody, but it's an attempt to see what we can do to help the court, corrections, state's attorneys, defender general, and others within the criminal justice system to drastically reduce the backlog so that people get their day in court. It's really what it is, and I don't think any of us are looking to point fingers. However, some people may, and that just comes with the territory. But I do want to start out perhaps by introducing myself and then kind of going around the room, since I don't know all the new House members. I'm Dick Sears, State Senator. I represent Bennington County and 4 towns in Windham County and 1 Windsor County. So,
Through Senate?
okay, and I chair Senate Judiciary.
All right, I'm Nader Hashim, Vice Chair of Senate Judiciary, and I represent Windham County.
Bob Norris, Franklin 1, which consists of 11 townships in Franklin County and Alberg and Grand County.
Tanya Vyhovsky. I represent Chittenden Central, which is the most populated section of Chittenden County.
Senator Phil Baruth. I serve with Tanya representing Chittenden Central.
Representative Ken Gosland. I represent the towns of Northfield and Berlin, and here I am.
Hi, I'm Representative Angela Arsenault, representing most of Williston.
Representative Thomas Oliver. I represent Sheldon and Swanton.
Representative Ella Chapin. I represent East Montpelier and Middlesex.
Hi, I'm Kate Donnelly. I represent Lamoille 2, which is Belvedere, Johnson, Hyde Park, and Wolcott.
Karen Dolan, representative from Essex Junction. This is my first time on judiciary. Last session I was on corrections and institutions.
Barbara Rachelson. I represent part of Burlington.
Tom Burdett. I live in West Rutland and I represent West Rutland, Clarendon, Wallingford, and Rutland Town.
And the Vice Chair of
House Judiciary. Thank you.
Yeah, Martin Malone, one of 5 representatives from South Burlington, and I'm the Chair of House Judiciary.
Great. Thank you all and welcome. I think we're going to start with Judge Zone. And Terry, if you want to join Judge Zone or you want to be separate, it's up to you.
We plan to tag team it a bit, so I'm happy to join him. I think that's going to make sense in case there's questions I might.
Yeah.
Okay.
That's fine with us, right?
Yeah, great. And before he starts, I want to say one other thing.
Oh, Representative Lamont.
Malone.
Malone, I'm sorry.
No,
it's new. It's new to me.
So there was a short form bill that we introduced, H12, just to help get the conversation started as well. And I know that the witnesses that we have today have seen that, and it lays forth a couple very high level ideas, and certainly want to hear comments on that, but and also just any other ideas for addressing the court backlog. So I'll turn it over to the witnesses on that as well.
Great. Well, good morning. For those who I've not had the pleasure of meeting, and for the record, I am Tom Zone, and I am the Chief Superior Judge. And with me today is?
Terry Croissant, State Court Administrator.
So we have been asked to talk about backlogs today. When we talk about a backlog, the first question I think that comes up is, what's a backlog? How is a backlog determined? When you look at the National Center for State Courts and other states around the country, they have dispositional guidelines, as does Vermont. And simply stated, a backlog is any case which exceeds the existing dispositional guideline. Dispositional guidelines, there's different guidelines for different categories of cases, and they can be changed. So Terry's going to talk about some changes that we're looking at for our dispositional guidelines. But it's important to keep in mind that prior to the pandemic, we had backlogs. It would be nice to say that the pandemic was the sole cause, but there were other causes that affected the appropriate case flow through the courts. And they're areas that we have and will continue to work on. But it's very clear that the pandemic absolutely exacerbated that situation and those circumstances. Well, how did it do it? Well, we had, as with the legislature and the entire state, we had severe limitations on our ability to schedule hearings. We had a halt for jury trials. We had to pivot, as did the legislature. How many of us thought the word Zoom was something that we would be going into a Zoom call? Right? This was something that was a change for all of us. And yet in the courts, we had the daily operation of individuals in custody, individuals coming in for important cases that we had to basically ramp up and get into remote so that we could continue operations at some level. We had the new Odyssey case filing system. For those of you who are new on the House and Senate committees this year, we went with a electronic case filing system that began, the first counties to go to it were Windsor, Orange, and Wyndham. And do you know when they went to that? First week of March of what year? 2020. It was right when the pandemic was hitting, we were switching for those 3 counties. And the decision was made to continue with the other counties also. That's been helpful because it allowed us to continue to do work without having to always be present in the courtroom or having people come in, because we could do things for filings and cases remotely, electronically. But like with many technological issues, I'm not going to talk about the FAA today, but we all saw there was issues yesterday. There are times when there's issues, and that also has caused issues with us as we were moving forward in the pandemic. We've had staffing issues, and I can see Commissioner Demmel, and he and I have had this discussion, that I know corrections is under significant staffing issues, just like we in the judiciary have been. And we've also had those magic 4 letters that people have heard about over the past several years, HVAC. And we have had courthouses that had grossly inadequate HVAC systems or none. And so we needed to take steps to assure public safety of those coming into our courthouses, as well as to plan for the future on how those courthouses are going to look. The other issue that comes up is that the pandemic brought a number of these problems and they exacerbated the situation. But we are always that one step away from an issue that can still exacerbate a backlog. If you have a county that has a jury draw and suddenly you have COVID go through that courthouse and the staff can't be there, or the judge or jurors are sick, that impacts our ability to go forward. If you have situations where there's not adequate security, I'm looking at Representative Oliver, he's aware firsthand, I believe, of the issues that we in the judiciary face when we don't have adequate security. And right now, we don't have the number of security officers we need to run the courts in the way that we would want to run them. Recently, we had a jury trial where in the middle of the jury trial, we were told one day that our court officer, or the security officer, the sheriff, couldn't be there the next day. And so we had to pivot and bring someone in from another court to be able to do that. And the judiciary has been taking those steps. We also have that technology issue that comes up. We use the network through ADS, the Agency of Digital Services. I believe the legislature shifted and went away from that several years ago, but we're still there. There have been severe and crippling issues that we have faced in the past 2 weeks. Just last week, I believe it was Thursday, was the most severe day. We're told that, well, things are going slower because of network congestion. We expect that network congestion to be between 10 and noon on Tuesday, Wednesdays, and Thursdays. It was pretty narrow. But what happened was we couldn't have hearings. We could not get the bandwidth, if you will. And I apologize if it's not the proper word, but we couldn't get the technology to get us to get Odyssey up and running because there was too much competition and the firewalls and all the other technical issues. We couldn't do what we needed to do. We even had to have some cases canceled. We had arraignments that were scheduled that had to be moved because the judge couldn't look at the files. Judges couldn't work on cases. Clerks couldn't process them. This all contributes to adding to the cases that are currently there. So let's talk about that. The cases that we are looking at when we're in the criminal division, our first point for actually all of our divisions is back in, except probate, is back in June of 2019. That's our best data point to begin with. We don't have the data from, let's say, March of 2020 as accurate as we do from June of 2019. So our starting point, let's start with June of 2019 as that last point before the pandemic. As you can see from this chart, at that time we had 5,016 misdemeanors, 2,565 felonies pending, and 628 civil suspensions pending. And if you look on 1/6 of 2023 now, we have 8,753 misdemeanors, 4,052 felonies, and 922 civil suspensions. I'll save you the math. It's a total of 13,727 currently, and it was 8,209 for a difference of 5,518 more cases now pending than back in June of 2019. Out of those felonies, for instance, 1,156 of them have been pending for more than 2 years. 981 have been pending for more than a year, and 358 from a year and a half to, from 9 months to a year. And so these are the types of numbers we're looking at for felonies. We look at misdemeanors, 2,200 of those, 2,205, have been more than 2 years. 2,163 of them have been over a year. Our dispositional guidelines for misdemeanors are, it should be 120 days for a standard, 180 days for a complex one. And so we are having difficulty, obviously, when we have that many cases. For the filings this year, in 2022, 64% of our filings in the criminal division were misdemeanors, 30% for felonies, and the remaining 8% were for civil suspensions. In the last 12 months, there were 40 cases resolved by jury trials. And I would point out that we are doing jury trials in every county. We are up and running. 12,367 cases resolved by plea or dismissal. That means 99.68% of the cases in the past 12 months have been resolved without having to go to trial. They've been resolved again by plea agreements or dismissals. And that number, it may be a little high, but statistically, it's always been up in the high 90s for the cases that will resolve by plea agreements and dismissals, as opposed to cases that go to trial. In our civil division, we currently have, you can see the breakdown for major civil claims and stalking and sexual assault, but we have 5,063 cases now. We had 4,712 back in 2019. Of those cases, there were 50% of the filings last year were for the major civil cases, 36% for small claims, and 15% were stalking and sexual assault, civil violation claims. When we look at our family division, we have that broken out by domestic, parentage, delinquency, abuse, and neglect. In 2019, we had 2,401 total cases. Now we have 3,463, which is 1,062. Look at the filings. The majority of our filings right now are chins in the family division. Chins, for those who don't know, is child abuse and neglect cases. Then we have following up that is the domestic, which is 21%, and protective orders 11%, delinquencies and youthful offenders 12%, and mental health we have 13%. And this is for filings. Active cases in probate. This actually has been pretty steady. In 2022 of January, that was the time for probate. Probate was on a different system, so we don't have the data back to 2019. But for probate, when we started the year of 2022, we had 6,861. And when we started 2023, we have 6,850. So that has remained fairly constant. So these are the numbers. We're going through them in each of the courts, and we're taking steps to address them. And it's important, I think, Senator Sears, you touched on it. in many ways, the question isn't, who do we blame? The question is, how do we fix it? Learning how we got here, absolutely. It informs how we go forward and needs to be assessed. If there are errors that any stakeholder made, we should look at them and say, okay, let's fix it. Going forward, the question really arises is how do we start taking the steps necessary to address the backlog? And be assured the judiciary has begun to take those steps and will continue to do them along with our stakeholders. We have meetings this week with the Department of State's attorneys, Defender General, corrections. So we are interacting in a way to see what can we do together collectively to make things work better in our courts for the citizens of Vermont. And so at this time.
Well, I may ask you a question that, and maybe Terry would be the one to answer it, but I'm going to ask the same question of John Campbell, Matt Valerio, and Commissioner Demmel. What did you do with the money that was appropriated in the 23 budget to help with the backlog, the one-time money? Has that been all expended? Did you have a hard time finding former judges that were willing to come in? Or what, did that do any good? I mean, obviously money isn't the only solution to a problem, but it was designed to help with backlog. So I'm curious as to what you did with the money and how that all.
Thanks, Senator Sears. I can attempt to answer that.
By the way, the last time I talked to Judge Zone, he had a tree just fell on his house and all in night. I assume that the tree is gone now.
It is. Thanks for asking. It's gone.
So Senator Sears, to answer your question, it's my understanding that there were several or three at least major kind of pots of money.
Yep.
So to answer, and one of them, for example, was 5.7 million that was mostly used for HVAC improvements to bring all the courthouses up to standards. And it's my understanding that now, just within the past month, all of the courthouses now do have adequate HVAC levels such that we can conduct, in particular, jury trials and jury draws, which we were prevented from before because we were limited as to how many people could even be in a courthouse. So 5.7 million was completely expended for the necessary HVAC work that's now been completed in all the courthouses. It's my understanding there was another pot of money, $7 million, that was primarily used to bring all the courthouses up to standards for remote technology hearings.
Right.
And that's been a critical improvement in tool that was necessary during all those months when we weren't able to conduct in-person proceedings. So now throughout the state of Vermont, every single courthouse is equipped with the screens, the large screens, the wiring, the laptops, the tablets, everything necessary to enable litigants to connect remotely, as well as witnesses.
My understanding is corrections is having a difficult time though on their end, providing you with the defendants to
Well, with the staff.
participate remotely. So
Because of the staff that's necessary to work everything on their end, and that's absolutely correct. We've had upgrades. There's been improvements, but they're
I
definitely.
mean, the technology's there. We don't have the staff to bring the offender to.
Right, and Commissioner Demmel, I know can address that. We've been meeting regularly in an effort to try to help that process, but it does come down to additional stresses on their staff to be able to connect the people, to print off the forms, to, have things signed, to do all the kind of processing that normally would take place in the courthouse. So that's been a big issue. And then there's another pot, which is the pandemic fund money, which is roughly $12 million. Is that?
That was what I was talking about, to hire staff to help with the backlog, but also to bring in, I hate saying ex-judges.
Retired judges.
Thank you, retired.
Right, and actually Judge Grierson, as a retired judge, has been utilizing that money because he's helping to try to help process the expungement orders that require a judge sign off. So he's primarily been doing that, but for that money, roughly half of it has been spent, and from what I understand, the remaining half is to be spent the next 2 fiscal years.
Yeah.
But that has covered limited service employees who were needed during the pivot to the remote hearings, because it required a whole new level of kind of technology understanding and training so that people could connect. If you all have had any, well, in the legislature, you're familiar with everything that was involved with making your hearings accessible remotely. So a lot of that went to limited service employees for that purpose, as well as some 3 dedicated solely for expungement orders.
Right.
And which are required, and everybody agrees with the policy behind it, but it's a very time-consuming, laborious process. There are 39 separate steps involved. It'd be nice if you could just click expunged, but it doesn't work that way. Between staff and judges, it's considerable time involved for each and every case, and we're talking about tens of thousands of cases ultimately. The rest of the money was used again for tech upgrades, different tech upgrades that I don't have the expertise to explain other than to know it has to do with the infrastructure. And kind of the wiring that's needed, especially in the older courthouses, and some HVAC work for state-owned buildings. Because I think the bulk of the other money was primarily for county-owned buildings that needed HVAC improvement.
Right.
So I'd say a combination of the limited service employees, tech upgrades, and HVAC work primarily is how it's been used. The 5.7 has been spent, the 7 million has been spent, of the 12 million, roughly half of that has been spent to date.
Thank you.
It's been extremely helpful. We wouldn't have been able to function without the remote hearing capability, and it's now a tool that we really look forward to using going forward because it does have many advantages. Some types of hearings, especially depending on case types, and certainly the criminal and the jury trials, are going to be in person. But you might have an out-of-state witness that would need to appear remotely. And it helps access to justice because we've heard, especially in the rural counties, it's really helpful for a person to be able to connect remotely to his or her hearing and not have to take a day off of work, travel, childcare, et cetera. So it's really been a silver lining, in a number of cases. So we're immensely grateful because I know we would never have, I'm sure, had the funding to upgrade the remote technology as we were thanks to those funds.
Any other questions for Judge Zonay or Terry on these?
I've got a few, if that's okay. So I just wanted to go back to the 99.68% number, and I was just curious what percentage of those are dismissed by motions for lack of a speedy trial, if you have those numbers?
I don't have those numbers. I could try to find out, but there may be, I can tell you, I'm aware of some cases that have been dismissed by judges for that purpose and that reason, but there's no central, when a case is dismissed, it's generally not something that our Odyssey system would track.
Okay, thank you. And the second question, we got the dispositional guidelines for misdemeanors. Do you also have for felonies, that information for felonies?
Currently, the dispositional guidelines for a standard felony is 180 days. For a complex felony, it's 365, and for a super complex felony, it is 700. It is 455. The determination of what makes a case complex has to do with, in a misdemeanor case, for instance, are there interpreters? Are there competency evaluations? Are there conflicts where the public defender can't handle the case initially? As far as felonies, it's the same type of issues, but then there's questions about, is there a victim who's a juvenile? Is the defendant pro se? Are there out-of-state witnesses? Is a pre-sentence investigation necessary as part of the case? And the super complex felony is something that involves a fatality or a life sentence case. The guidelines were adopted by the Vermont Supreme Court in Administrative Order 24, 2010. We are evaluating them at this time, and Terry can talk about that as part of her discussion on the backlog plans, but that is something that we have evaluated, and there are proposals to adjust them at this time to take into account where we are and the realities of what does it take now to get a case to finalization.
Thank you.
Yeah, I'm sorry. Did you want to?
Oh, yeah, I can, Karen, go ahead.
Did you do for the House?
Yes, I will. Yes, absolutely.
Right. Thank you for this update. I appreciate hearing the pieces on the budget allocations or, and how that helped. I think there's curiosity of what have you seen as the impact or when will we see? Because right now, looking at those numbers, it looks like there hasn't been an impact in decreasing the backlog with that funding coming through. I think the flip side is it could be, well, it prevented it from getting even higher. So I would love to hear your thoughts on that, since that a large chunk of money was put towards it.
You're right. And Representative, that was kind of going to be my answer. Thank goodness for the remote technology. Those numbers, I don't even want to imagine what they would be otherwise, because with remote hearings, we could at least, on a slower basis, on a slowed down basis, continue processing. And I don't want people to have the impression that the courts ground to a halt, because all during the pandemic, there were cases that went forward, in particular in the juvenile docket, emergency relief from abuse orders, as well as criminal orders. I mean, those went through no matter how we had to do it, whether it was, remotely or in person with, very few people allowed in the courtroom at the time. Those cases continued. In all honesty, the civil cases or the non-emergent family cases suffered because they were not prioritized, and those numbers built up. In the probate docket, it's interesting that the numbers remain stable, but I think that's largely in part because you don't have jury trials in probate. And jury trials, you might say, well, how many jury trials? There aren't that many, but that's what is the primary mover of cases, certainly in the criminal docket. It's only when you have a jury draw date set in the jury trial, certainly, that you see movement in the cases. And that's really what led to the backlog in the criminal docket. And then in the civil docket, in terms of civil jury trial cases, that was the primary reason why things ground to a halt. It's just a kind of a reality of, I think, trial practice that you don't see. And certainly John Campbell and Matt Valero could speak to but that's what was the primary factor. So that now that we're back in person, full capacity jury trials, we're seeing cases moving much more quickly on round. The backlog didn't build up overnight, and it's not going to be resolved overnight, but we're definitely on the right path. And we have the now extra tools with the remote to help things move even more quickly, and the electronic filing and case management system.
And I would also point out that if you look at the chart on the screen right now, at the beginning of 2022, our pending misdemeanors was 9,800. Now, 8,753. Same with when you look at the felonies, 4134, now it's 4052. And that's not a huge drop off, of course, but that is trending in the right direction. So when we have opened up more last year, when we are conducting more jury trials, it does show in the data that we are having less cases pending. We also keep track of clearance rates. Clearance rate is how many cases are coming in and how many are going out. What we want to see now is a clearance rate in excess of 100%. Some courts, we are having significant clearance rates of 150%. Some months it looks almost like an EKG. You get some months that you move a lot. And that, as Terry points out, coincides with the jury trials. Because when that pressure is on and the cases are going to be going to jury trial, there's a greater incentive for the parties to resolve the matter. And so we're trying to work on taking care of that to make sure that when we're going forward, we do have that keep going down. And I think in many ways, really what we did was we prevented it from getting worse. And that actually helped. We, as Senator Sears pointed out, he mentioned retired judges. This is an all hands on deck. Senator Sears, you may have heard, Judge Howard's been back in town. We've even brought him back in Bennington at different times to help out. Anytime he's willing, we'll do it. Up in Franklin County, Judge Van Benthuizen. Caledonia County, you have Judge Bent. We have Judge Cooper Smith from Chittenden County. We have judges who are coming out. We have 3 more judges who just retired. And I have asked them, when can I start using you?
Judge Teachout, who never even actually retired.
Justice Teachout is?
Well, Judge Teachout retired officially, but honestly, since then, she has been helping with backed up civil jury trials. And she'll go from courthouse to courthouse. If it's a week trial or a 2-week trial, she'll sit. That then frees up the judge that's normally assigned to civil to do all the other cases. So everyone is really working incredibly hard.
I never suggested you weren't working hard. Hopefully no one feels that way. It's just trying to get answers to what we can do, as I said earlier. Representative Rachelson and then Senator Volsky has a question. Did I mispronounce your name, Tim?
You got very close.
I'll get there.
I need to maybe spell it out phonetically on my name tag.
That probably would help me.
So I have 2 questions. One is, I understand that the backlogs vary from county to county. And through some of the other committee work that, for committees that I'm on, the discussion with people of what ideas could happen to address the backlog has come up, which I've made a list of and at some point would love to circulate for discussion. But given that some counties have had some good success, I'm just wondering if you can share with the committee any data you have about counties that don't have a backlog right now or have a limited backlog.
Actually, that's a good segue too. We have, in addressing this issue and asking similar questions to what you all are asking, we asked what would be most helpful. I said the court administrator's office has said, what can we do to assist in court operations in each county? And we did develop a statewide judiciary backlog plan. And then we've asked each individual county or unit to develop their own plans, understanding that circumstances vary. I think in answer to your question about what counties have less backlog than others, I'm going to venture to say, and John Campbell and Matt Valeri and Judge Zoney can correct me, but I know in certain counties, I think in the criminal docket in any event, the relationship between the state's attorney and public defender oftentimes makes a difference in terms of the speed at which cases process. So that may be the single most, most significant explanation maybe for in the criminal dockets in any event. But the statewide judiciary backlog plan, just to give you kind of an idea of what we've been looking at, is scheduling measures, making sure that there's a next event set in each and every case, making sure that when somebody's in the court for a proceeding of any sort, whether it's a status conference or motion hearing or whatever, that there's something scheduled next. So we've had it so that each county does all their calendars at least 4 months out, so that you can have a hearing date set. There was also in the transition from the old VTAD system to the new Odyssey system, the need for data cleanup, because we found a lot of errors in kind of the transition and the transfer, whether it was coding errors or other reasons why a case might be categorized as being an old case when it may not have been an old case. As an example, if there was a family case that ended, and then it took a year. And then 6 months later, there was a post-judgment motion. In the transfer, it showed it then as a 2-year-old case, even though it really was a brand new case. So we're also, our technology services center is doing, they have a data cleanup program to make sure that the data is accurate, because we found that there was a lot of error in the transition. Also reporting measures for the data, like the charts that Judge Zoney is showing. We've asked the courts what can be of help to you. And it used to be that they would get quarterly reports, for example. Now they're getting monthly reports of their clearance rates, and the reports are done. Kind of in the past, it would be, well, here's what you do to arrive at this report. Go through these 10 steps. No, now we're like, here's your report. Recognize that you don't have the time to go through these 10 steps, and they can be updated daily. So that's another measure, that's to give them the data so they look and see where's the progress needed, where's progress stalled, what can we do to attack it. Now there is the judicial officer and retired judge. To give you another example, most probate judges are part-time. I think Chittenden County is the only county with a full-time probate judge. So we have several probate judges who are part-time for probate duties, but they are working in their non-probate time, sitting on small claims cases, relief from abuse cases, stalking cases, freeing up then the civil judge or the family judge that would otherwise be hearing those cases. That's another kind of example. Judge Zoney mentioned the dispositional guidelines. He mentioned the criminal one from 2010. So that's, 13 years old. And we recognize that most of these dispositional guidelines were on average from 8 to 20 years old. Are they realistic? And we found out, checking with the National Center for States Courts, which has their own guidelines, they indicated no state in the country is meeting these dispositional guidelines. So to us, that meant if they're not realistic, first of all, it's demoralizing. You're working like dogs and you're not meeting these. So we did a survey of court users, practitioners, judges, court staff, in terms of what are realistic dispositional guidelines. And those have been developed, and we're utilizing those so that it's something that if we're not meeting the realistic ones, why not? If we are meeting them, great, let's, continue. So those are some of the ideas and steps, and units have been developing the backlog plans. They're posted on, we have a JusticeNet kind of web intranet site, so people can see what other unit plans are, get ideas from them. And they've been great, involving also the local, they do bench bars to get input from the state's attorney, the public defender. They have also regular meetings now with court operations manager, judge, state's attorney, public defender. What can we do? How can we target these cases? So those are some of the measures that are being undertaken. And it's almost been, in a sense, competitive where, people are taking pride in saying, oh, we've made progress. And something we're kind of all focused on and trying to do our best to creatively and with the resources that we have address it.
Thank you. So my second question is related to budget. I have been the House Appropriations rep from House Judiciary to, I said that backwards. And I know that unfortunately, both of your predecessors didn't come to our committee with the 3-year plan, and so they went to the Senate. And so we weren't as part of sort of learning about that. However, in just doing our own research for me to report back to our former House Judiciary Committee, I understand that both the Defender General's office and the state attorneys originally had 3 years of funding that they were requesting and peeled back their requests. And I know that some of the delays are related to, in criminal cases, defendants not getting a chance to meet with their attorney until trial day, or so it's unfortunate. So it's unfortunate that that didn't happen. And I'm hoping moving forward, we can all kind of think together and sort of be part of it. The question that I have related to budget is there were many temporary positions that got added to the budget pre-lockdown, mostly related to expungement, but I think also to the Odyssey transition. And right before, sometime before your predecessor left, I know that many of those positions did not get used as they were intended because the needs changed with lockdown. So I don't know if you can speak to the status of, because it was like 60 temporary positions, I think. I don't know. I didn't bring my appropriations budget file.
My part is because I don't have familiarity with that particular report that you're referring to, but I know in terms of limited service employees and the plan in general, and I think it might have ended up being 40 or so if I have the number right. A number were used in the implementation and rollout of the Odyssey, which has now ended. The rollout has been to all the courts, including the Supreme Court. With the otherwise limited service positions we use for the pivot to remote hearings. And some will be ending. The date now is June of 2024. But a number of limited service people who joined court staffs have become indispensable part of court staff. Sure. I worked in the courts for like a 9-year period, ending in 2016 or so. And I can say for sure, from my experience, courts were understaffed then. I mean, it really honestly was, everybody was there, nobody was sick, nobody was on vacation, maybe you could get by, but that wasn't the reality day to day. So I, in coming into this position, made it clear that would, a priority on my part would be to make sure there was adequate staffing in the courts. We are making a staffing increase request, including ideally having those limited service people who've become indispensable to court operations being offered a permanent position. If the staffing request is agreed to or approved. Otherwise, we're trying very much creatively through whether it's attrition, through recruiting, through retention measures to try to even out and make sure that there's adequate staffing in all the courts throughout the state. But I'm afraid, well, it all depends on, I guess, whether the staffing requests are approved.
And some of it was definitely related to expungement.
Yes.
And is that project's?
Yeah, that's kind of a separate project.
Okay, I just wondered if that's contributing to the backlog.
Well, it's certainly in the sense that we have a number of personnel working on expungements that are not then able to work on normal court operations. I say normal, just day-to-day court operations. But the number of cases, the total number of expungement cases to date is 54,117. That's how many have been completed. And there's I'm going to say 30,000 that we know of that remain to be completed. And there is a plan. Challenge is it's a moving target because they're continuing to, it's not as if there's a set date, and that's the expungement cases that we're working with. And then some of them are automatic, and then some have to be petitioned for. So right now, there are 3 persons working exclusively on expungement, and Judge Grierson is the judge processing them. In every court, when they have time, they're working on their individual ones. The petition ones are responded to, immediately. But there's tens and tens of thousands of other ones that we are, doing our best to resolve. But that is part of the staffing request because it's a time-consuming process.
Thank you. And sorry to go off.
Thank you. I have a couple of questions. One is related to the expungements. So that does include the cannabis expungements, which I believe is now automatic.
Right, the Act 167. Right, of that, there's been 3,700 done so far. We anticipate another 17,000 are out there to be done. The automatic ones are the no conviction, where the defendant's completed diversion or deferred sentencing or a successful completion of the youthful offender. Those are the automatic ones. And then by petition, non-DUI, DUI, the Act 167. And again, everybody acknowledges and recognizes the importance and the all the benefits. It's just a matter of having the manpower to do the processing.
Understood. And then I am wondering if you have the county level breakdown or unit level breakdown of backlogs available.
For the expungements?
No, just in general for the.
Oh, county by county.
Yeah.
I have with me a sheet that's pending criminal cases as of 1/11/13 that has under dispo guidelines, near dispo, over dispo, and total pending cases. And I actually calculated this morning the percentage over dispo, which would be the backlog. And I think Representative Rachelson, that ties into one of your questions. It goes from a low of 38% in one of our counties up to several counties. One county is 70%, some are 69%. So it does vary by county. So I can certainly get you that.
That would be awesome. Thank you. And then my last question, well, it's kind of two. So I understand that the docket clerk position has recently been transitioned to a judicial assistant, which requires more time in the courtroom. And I'm wondering, which leaves less time for docketing. And I'm wondering what impact, if any, that has had on the backlogs.
Well, the vast majority of courts throughout the state already involve their docket clerks in the courtroom. And actually, when you're in the courtroom there's entries that are made in conjunction with what is happening in that hearing, but you also have time to do docket work when you're in there. Because, you'll say who's here, who's present. And then there typically is a law while whatever is transacting. You need to enter whatever happened, whatever the result was. But it doesn't prevent you from also doing docket clerk work in the courtroom, even if you have that role. Part of the reason why the change is the judicial assistant resulted in an additional pay increase, which was badly needed for court staff personnel. And the remote hearing part of it also necessitated having somebody overseeing that. But to your point, though, it's a matter of how do we account for all the work that needs to get done. But for that particular question is you can do court processing still. Of course, not as much as if you're sitting at your desk. But when you're sitting at your desk, one advantage of being in the courtroom is you're not having to answer the phone or work the counter. So it's kind of a trade-off in terms of what your responsibilities are.
And I could also comment that it's also beneficial, I think, to the judges. When you have the judicial assistant in the courtroom, that means the judge doesn't have to stop every hearing and go, okay, now I have to make a note for the next hearing. He can look at the clerk and say, the next hearing we need to schedule for this. Can we get that done? The clerk can do it immediately. as opposed to the judge going into Odyssey, doing an order, sending it as a task to the clerk. They have to open it, they have to do it. So it actually is beneficial to the court to enable it to efficiently move through the cases in the docket.
Wonderful. And then right now, what is your job vacancy rate? Do you have a sense of how many open positions you have that need to be filled?
Within the courts, actually, we've done well, and I'll tell you why. It's really interesting. There's this whole emphasis on workforce development, right, statewide. And in the courts, we're taking a much more proactive approach to recruiting. Instead of just posting and hoping and waiting that somebody responds to it, we're actively going out too, whether it's guidance counselors, to community colleges, to areas to say that here's an opportunity for a career in the courts. And there's such a public service kind of interest level among young people especially. It really appeals to them. And we're touting how you're doing, if this is public service work, you're doing something that's vital for your community. You're involved with the rule of law, access to justice. So that really has resonated with young people. So we've been very successful in terms of having people apply. Of course, retention, everybody, is figuring out ways to retain as well. But right now, we're actually, in terms of the openings that we have, we're asking for more permanent positions to be able to, post. But we don't have that many that are vacant as we speak. There's kind of a constant, there's always somebody somewhere, attrition, retirement, whatever. And during the pandemic, which is, I think, true across a lot of different industries, there was a lot, people decided, okay, this is a time to retire. So we did lose a lot of very experienced staff, which was, a disadvantage. But at this moment, we actually don't have as many openings now for those that we're able to post.
Wonderful. That's great to hear. I heard yesterday from the state's attorneys that the caseloads are particularly high, really unmanageable. What growth in deputy state's attorneys do you think is necessary to help manage what's coming in?
Oh, gosh. Well, John Campbell would be the best.
Perfect. I'll wait for John to get here then.
We'll take 100, thank you.
I know they're really challenged, and Defender General's office as well.
So I have a couple questions as well. So the 2,200 dockets, and I'll pretend that there are 2,200 people. I know that's probably not the case, that are misdemeanors who that are longer than 2 years. How many of those folks have been living under conditions of release for those 2 years? Is it pretty much common that misdemeanors do get conditions of release? How does that work?
The court has to consider whether or not someone should be released on their personal recognizance unless there's a risk of flight or there's public safety conditions that need to be imposed. I don't have the data right in front of me. I can look to see to try to get that to know conditions. Not everyone has conditions, and I should be able to find out how many of those cases have the conditions of release order, so I can let you know that.
Is it, do you have any ballpark as far as percentage that of?
I don't have any ballpark. I think generally most people across the state do have some conditions.
Right, okay.
So I think that it's safe to say that the vast majority of cases probably have conditions of release.
Okay. The other question is, of those 2,200, how many are fines only as far as misdemeanors? And you may not have that right now either, but both those things I think would be of interest to understand.
When you say fine only, are you referring to a case that the maximum punishment is a fine?
Yes.
Or
yes.
The state's attorney at the time of the arraignment has indicated they will not be seeking a term of imprisonment or a fine of more than $1,000, and therefore the case practically is a fine only?
Yeah, the practical fine only is definitely.
I'll see if I can find that information out.
So a couple other questions. So the realistic disposition rate, I think you've sold that very well, but when I hear that what we're doing is we're not meeting our goals, so we're going to move the goalpost. And I'm not saying that wasn't completely proper, but I would really like to understand what the factors that were taken into play. And again, you don't have to answer this right now as far as how to determine what that realistic rate was. I mean, is it realistic under a pandemic situation? Is it realistic with full staff? if I could find out a little more about how that was set, that would be helpful.
And we haven't yet applied those new standards. So the figures that you're seeing here are the dispositional guidelines at present. This is something that we did through a survey and then looked at the results. And Judge Zone actually kind of was one of the two people most involved in that.
Yeah, we could do a follow-up on that one. I don't need to spend much
The
time.
brief answer, though, is that there is no hard number as to how long it takes. When we're looking at the cases right now, the question that we looked at was, okay, if you have a misdemeanor charge filed in, we'll say, Windsor County today, is there any chance on that case going to trial in the next 6 months? And I think the answer to that is no. It's not going to happen. Because you have people incarcerated, you have serious felonies, you have other cases that are much older that are going to be there. And so the question is, do we set up a dispositional guideline knowing that for someone who is exercising their constitutional right to a trial, that we will never meet that guideline? And so what we're trying to do is assess that and come up with a number that is realistic where we are now, but is going to be reevaluated as we go forward.
All right.
Yes.
Thank you for that part.
We could say that the dispositional guidelines are 3 years. Senators, we have no backlog. That's,
right.
What we're trying to do is come up with something that says, this, as Terry pointed out, this is attainable. That we know this is a benchmark we can go to, because if we're setting dispositional guidelines that on day one, we know cannot be met in any county of the state usually, what are we really setting out? We're setting up failure for the state's attorneys, the defense attorneys, the courts. No one's meeting it. So our goal is to come up with dispositional guidelines that reflect where we are, where we need to be, and where we're going to be going in the future.
So one other question. So Judge Maley, November 2021 order seemed to really address the issue of backlog. Not necessarily going forward, because there's things that can be done going forward, but had the state's attorneys and the defenders get together and look at old misdemeanors primarily, I believe, with a list of factors and come up with ones that could be dismissed. So a couple questions with respect to that. Why haven't more judges done that? And can we somehow get more judges to do something like that?
The issue that happened in Franklin County was one where the parties got together and discussed what's going to work in this county. We have 14 counties with 14 separately elected state's attorneys. Each of the counties have defense attorneys who practice in a different way. And I'll let John Campbell can talk about the state's attorney side, but the Franklin County situation was one where there was essentially buy-in from the parties. I know that every attorney and every judge in the state was well aware of what, I suspect, was well aware of what Judge Maley did. And I'm aware of discussions across the different counties about whether something like that may work. The question for the judiciary is there a valid basis to dismiss something? And that generally comes to the judges by motion and by the parties bringing something forward. And I do know that going forward, judges are looking at this as to, is this something that the parties would get together to see about a resolution? It's been one that the stakeholders have discussed. But we do have the Rule 48 talks about the limited ability of the court to dismiss cases over the objection of the prosecutor. And there are constitutional separation of powers issues that the judiciary has to make sure it follows.
And this goes to a question that we frequently are looking at, and that's geographic justice or injustice. And we could have a county and prosecutor who is having some of these 2,200 people who have been living under conditions of release for more than 2 years, where another county is taking care of those cases. And that's I think a big concern, is that different justice in different counties. Yeah, so I guess I think Kate had a question, but in wrapping up, if you could give us a summary of what your main points going forward. I know we've talked a lot. If you could just bullet point, here are the main things we're doing going forward to take care of the backlog. But Kate, I think
whatever order you want to go. You want me to
I want them to
first?
finish with kind of the because I think we're about done with these folks.
Well, I have one other, but.
Oh, okay, yeah.
Okay.
Thanks. Yeah, my question is related to family court. What I'm hearing in my community is a lot of concern about backlog related to CHINS cases, truancy cases, youth, high-risk youth who are really not receiving access to courts right now and the impact that's having in homes. I guess I'm curious, a couple questions maybe I'll just throw out. One, what are the dispositional guidelines for CHINS cases and how close or far are we from that? It sounds like the courts are set up in such a way where there's some flexibility around what gets prioritized during these times, which I imagine is great. I'm curious, where do CHINS cases fall in the prioritization list of things? And then third question, what role does your office play in sort of offering guidelines to the counties around what cases should be prioritized?
The first question about dispositional guidelines, I do have them, but I don't have them in handout form. They're in another, I'd have to access them electronically on my other computer. Otherwise, I'd lose the screen.
That's fine.
I can get you that.
Thank you.
As far as where do they fall on the level of, if you will, priority, they fall at the very top. With the cases that we are prioritizing are the CHINS cases, are the criminal defendants cases where individuals are incarcerated. Those are the cases that we need to move forward. As far as going forward and how we handle that in the counties, each county has a setup for, do you have a single judge handling those, or is there a judges handling those several, like in Chittenden, you have more than one judge who will handle the family docket. We are highlighting for the judges the fact that if you need additional judicial resources as far as retired judges, we will assign them if we have them. The retired, I cannot think of a time since I've been chief superior judge where I've been asked by a court to have a retired judge come in to help out that I have said no. It is always, if you can use them, they're willing to do it, yes. I note that one retired judge looked at me and said, you know, I retired for a reason, and I don't want to work full time. But the reality is we are trying to highlight those juvenile cases, including the termination of parental rights. We're trying to take steps to make sure in those cases to get those children the permanency and families the permanency that they need to taken care of, prioritized. It was mentioned a few minutes ago about Terry mentioned about the staffing and how we're trying to make sure we have adequate staffing. We are down 3 judges right now. I'm not sure if everyone's aware of that. We have 3 retirements at the end of the year. And as of April 1st, we'll have another judge retiring. The governor does have the names, I understand, of the candidates for these 3 positions. And once they are confirmed.
Oh, I didn't see him.
No, she just
One of my goals is that when we have that happen, we are going to be able to use judges to the task force. Like Judge Teach Out, we're using to go in to help out in the civil cases. That's an area. If she's doing a civil docket, that may free that judge to go and help out in the CHINS docket. But we are prioritizing that.
And as part of our request to the legislature for additional staffing, there's also a request for an additional judge position. And the idea would be to go and take the oldest TPR case that needs to be heard and try to target those kinds of needs. In terms of priorities for the legislature, I didn't have a chance to get to, but I'll briefly mention security, courthouse security is a matter because sheriffs, like all law enforcement, are having very significant.
You know how much hair I had when we started this on security? We need to solve this problem. I'm not sure we're going to do it today, but I have spent, I think, more time in between appropriations, judiciary, and House Judiciary, trying to deal with, and the governor's office, who didn't always fund your security the way it should have been. It is more than frustrating to hear that your continued problems, and we have court, and I know it's a little bit off subject, but not Senator Campbell, John. Executive Director Campbell can respond. At a time when we're having more and more remote hearings and we're not transporting deputies, I thought we left the message that you could use transport deputies for courthouse security when we left last May or whenever it was we left. And somehow that evidently hasn't gotten transferred down, because if they're not transporting, what are they doing?
Well, that would be a question for the sheriff's
I
department.
realize that. I share your frustration on courthouse security and the independence of 14 sheriffs who seem to not see it as much of a priority as most of the public would, that you have to provide that courthouse security stuff. It is more than frustrating to hear that we're actually worse off than we were before we solved the problem last year.
I think the problem more is personnel. At least that's what we're
Yeah,
told.
but what are they doing?
But I guess they have to in the sheriff's office and not enough.
Maybe they're out directing traffic for AT&T, I don't know.
So I just mentioned it because it impacts the backlog, because if we don't have a court officer, we can't conduct the hearing.
Well, I understand all that. I mean, but I'm just sharing with you my frustration that the amount of time we've spent trying to solve the security problem, maybe it's time to go in a completely different direction. But I'm sure John Campbell will have some advice for us.
And we have shifted to actually hiring personnel and using private security.
I know, but it doesn't, when you, again, I had a lot of hair when starting this company.
And the very last, I guess, in terms of the legislature and proposals to the legislature, is the ADS system that Judge Zone mentioned. We cannot continue where we have our system shut down and we have a courtroom full of people. And so we've made a request to be able to separate, as the legislature did, from ADS. There's a price tag associated with that, but that's definitely an ask that we have in an effort to try to just do normal court day-to-day operations, let alone for that.
Well, that says something about our IT system and the state government, I guess.
I would also.
I'm honestly, that's out of my league, but.
Is that a one-time fund?
Yes.
One-time money to change out of ADS?
Yeah, we submitted the proposal to House Appropriations and.
Okay.
But you would ask about, what we're doing, and I think that we've talked about the backlog plans and things like that. And the one other thing that needs to be front and center is that word communication. I'm looking out here, I see John Campbell, I see Commissioner Demmel, I see Defender General Matt Valerio on the screen. We do talk, we do meet. When we have issues that are impacting our ability on any of our agencies in our branch to be able to do what we need to do, we talk about them and try to resolve them and try to come up, if you will, brainstorming with the stakeholders to see what's going to happen and what's the best way to address things going forward. And I can say that we don't always agree. We always agree on one thing, and that is we need to keep taking steps and considering all options as we go forward. And that's why when I hear Representative Rachelson and others say, well, they have ideas, let us know. It is very helpful.
I think Coach had his hand up for a while.
Yeah. Senator.
Representative Christie, go ahead.
Thank you all. Good morning, everyone. Interesting discussion. A lot of my questions were answered, especially regarding the triage, utilizing the guidelines. And so that is helpful. I, like Senator Sears, is very concerned around the security aspect, because we have been fortunate that we have not experienced a major disruption. And I mean, that's just luck, because at any given point in time, we could. In 2017, I think it was the Court Administrators Association did a survey for us as far as what our need is for adequate, not over the top, just adequate security at all of our facilities. And needless to say, we're nowhere near that. Senator Sears's point is well taken, and I picked up a few extra gray hairs over that one as well, Senator. And I'm with you. Anything that I can do to help negotiate a better stand. You know, this needs to be addressed. And I'm having a very difficult time accepting excuses. You know, we need to do this because, you know, we've got to protect all sides of our court. You know, we don't want to have any of our court staff hurt. We don't want to have our judges hurt. We don't want our participants being hurt. And we've just been lucky. So of all of the points, I guess that's where I'm at. I'm with you, Senator.
Thank you.
Thank you. So I am curious, and you might not have the answer right now. I know that it's a one-time cost to sort of make that transition away from ADS, but I wonder what the one-time cost of just upgrading the ADS system to meet the need is. Because what I worry is if the system is just not being invested in and upgraded, that more and more state or agencies are going to leave and there's going to be one-time costs here and one-time costs there that will ultimately add up to more over time than simply upgrading the system.
Right. I don't have the answer to that question, but I think it would be Secretary Naylor that could investigate. I know we have been in daily communication in terms of the issues, and so far there, as far as I know, there isn't a suggested resolution. Other than saying, well, too many people are using it at once, but you know, we can't operate that way. Thank you.
Other comments from either of you? It's been extremely helpful. I hope you.
We just very much appreciate the opportunity to
And
speak with you and your interest.
We
And
do look forward to hearing about IT. And I guess that's going through the appropriations process, so.
we had asked for it as in the Budget Adjustment Act is how we're hoping to pursue it.
Good, well, the House gets first crack at that. It's good. Any other questions for either of the? Great, thank you.
Thank you very much.
Thank you.
Thank you both, it's been helpful. John Campbell.
It's a break time? No.
I'm sure you'd like one. We don't mean to be argumentative,
I'll
John.
take my jacket off now so you can whip over.
No,
Thanks.
I don't want to.
Take a seat.
I don't think anyone on the committee, the committee wants to, single out the sheriffs as a major problem. I think our focus was mainly on the state's attorneys and dealing with the backlog. And I think my main question for you, and maybe you're here to answer it, is what can we do to help you to reduce the backlog without destroying prosecutorial discretion, which, obviously prosecutors may have reasons for not wanting to dismiss a particular case as, maybe on the face of it doesn't look that serious, but maybe more about it, or the victim is a real concern, really concerned about it, and we don't want to. So I think if we could start there, but also obviously a little response on security. I'm obviously disappointed to hear the news that that we're actually going backwards on courthouse security, not going forward.
Well, as Paul Hartley used to say, because Terry is not, and I, with all due respect, I'm not sure she realizes how many places we are doing this at. So providing security, and I have Annie Noonan is on. Annie is the one who's she is in charge of the transport deputies, and she can respond exactly to what we're doing with those, because you all last year, you're right, you provided the authority for us to tell these transport deputies that if they're not doing something, we can assign them to other jobs, which we have been doing for human services and DMH, also for court. But Annie has more specifics. So if I could ask you to recognize her, Senator, I think she'll be able to provide it.
Good morning, Annie.
You're muted.
Excuse me, Senator.
Yes.
Sorry to interrupt. Could we do introductions?
Oh, sure.
Before we start?
Sorry.
Sorry, and apology. My name is John Campbell. I'm the Executive Director of the State's Attorneys and Sheriffs.
Tim Leaders-Dumont, I'm the legislative attorney for the department.
I'm Annie Noonan. I'm the Director of Labor Relations and Operations for the Department of State's Attorneys and Sheriffs.
Thank you.
Thank you. So Senator Sears, good morning, and good morning to everyone. So I do want to say that the legislation that was initiated from the Senate last year did give us a lot more authority to direct the state transport deputies. And I think that has worked to the benefit of state government. And we are doing courthouse security in many areas. Our Addison County Transport Deputy reports every day to the Addison County Courthouse. I know that we're doing a lot of court security work in Windsor, Washington, Chittenden, Orleans, and other counties around the state. We have basically said that when the state transport deputy is not doing a transport, which basically their primary job is to pick up folks from the correctional facilities and bring them to court for their hearing and back. We have said you will cooperate and work in the court system for extra security, and you'll work with the Agency of Human Services. We do post-arraignment release transportation back and forth, which is through DOC. As long as the person being released is willing to continue to stay in state custody till they get back to their town of origin. So if, for example, they're being transported from Brattleboro for a remote hearing in Springfield, and then they are cited to appear at a later date, they really often, they don't have a way to get back from Springfield to Brattleboro. We call that the post-release transport program in connection with DOC, and we bring them back to Brattleboro as opposed to having them fend for themselves, which is often not realistic. They often don't have any way to get home or money to get home, so we bring them back. We're also doing more work with the Agency of Human Services in supporting supervision of youth that may be housed at a local police department before they're able to find a placement. So there's some more work being done with supervision. And we're in conversations with Human Services and Secretary Samuelson with regard to how we can do more work in connection with the Agency of Human Services, particularly around DCF. But I would say that given the language that was passed, we have been able to work with the sheriffs so that people are, when our state transport deputies are not transporting, that they are able to help out in other areas, supporting state government, supporting all of state government. So I think that's been a very positive development. There are some areas where we have some vacancies, but we are not as bad in our recruitment for these positions because they have their state positions, they have state health insurance, state retirement, and for the most part, not exclusively, but for the most part, they are able to work what I would say a more normal schedule than some other law enforcement agencies. So for example, they're not doing second and third shifts out on the road. They're not working weekends. So this tends to be a job where if someone separates from a state transport deputy position, other law enforcement people, like within a sheriff's department, often raise their hand and say, I'd like to apply for that. So it's actually, we don't have a big turnover and we don't have a big vacancy rate. Right now, the vacancies that we do have, we're really holding until we have a more extensive conversation upcoming with Human Services to see how we might be able to be using them more effectively to assist in human service activities. So I think things have gotten better. I think everyone heard loud and clearly that what was going on, and you know that I was very frank and honest with the committees last year about my own concern about people shouldn't be sitting around. If they have nothing to do, raise your hand and get out there and do something. So I think things have gotten better, and I appreciate the work that the legislature did to give us more authority to help for us to do this work. Thank you.
And I must say that Annie's being nice by what she's saying right now, because I hear her on the phone every day talking to these guys, because we have like 27, I believe, transport deputies. And she is very, very specific with them that they are not to be just sitting around. And as she said, so we're doing a lot of work with mental health. And also, again, this transport after the arraignments has been really big, and it's helped a lot of folks that have found themselves in the system and have no way to get back, that we are doing that for them. So
It's helpful to hear the other side of the story, but I just wanted to emphasize what we heard this morning from the courts, and having one county, give up on security. It's a challenge.
I just think the need is probably more than certainly than what we have now.
But at least the transport deputies issue is being worked on and has helped alleviate some of the problem. I guess it'd be worse if we didn't do that.
Yeah, it's just unfortunately, there's a lot of things out there. There's a lot of, and I'm sure the commissioner will tell you also, and if you have talked to the commissioner and the secretary of AHS, they'll tell you, DMH, we get calls every day. Can you lend people here? Can you, especially also with the juveniles, when you have a juvenile that's out of control, we've assigned 2 of our deputies to go and sit with that individual until they get through their crisis. They just, DCF just does not have any folks to help with these kids, and it's terrible. And and I'm sorry, but the children should not be stuck in jail, and they don't belong in a hospital. They belong in a place where they can actually get some help. And our deputies, the ones that have been doing this, are extremely emotionally involved with these children, and they really care. And they show that they're there to try to help and calm down the situation.
Go ahead.
And okay, so would you like to go back to the other, or do you want to have this already?
I'd like to go back to the state's attorney's role and the backlog, and from your perspective, what answering some of the questions about how we should be dealing with this backlog. And I think it starts with how can we reduce the backlog, but at the same time give prosecutors discretion, which I think is required under the Constitution and required under the
I wish there
separations of powers.
was a silver bullet, and one way to just say, okay, we'll fix it this way. There's a couple of things, especially number one, the first thing that comes to mind, if these were all victimless crimes that were there, and then this would be probably a simpler problem. But it's not. I mean, you have, the misdemeanors, people are talking about just a blanket dismissal of misdemeanors or even nonviolent. Those are still some violent cases. Those, you have domestic violence cases that are actually misdemeanors. And under the definition of what a violent crime is, those still could be in that blanket. So, it's unfortunate, even when you look to some of the property crimes, because I can't tell you the number of times that I get calls and say, why aren't you all prosecuting this, let's say, shoplifting? And everyone says, okay, well, shoplifting, that's not really that bad. Do we need to really go through the whole send them to, or try the case and try to incarcerate people? The answer is no, we don't try to do that. But then from a shop owner, and I'm not talking about a big store, but I'm talking like the mom and pop stores that are right here on Main Street, when they can't absorb the type of losses that they're having. And the individuals that are generally doing these things, there are multiple dockets. So it's not as if they're, someone's going in and shoplifting from one store and that's the last time they do it. It's pretty concentrated, and it's also one of those situations where, there are businesses that are going out of business or are being really hurt financially. And so they call us and say, why aren't you prosecuting? How could you drop that case? And, we have to explain to them that, the system, unfortunately, is not set up right now. We don't have the resources to handle all of these cases. And then going back to what we have and what we've been trying to do, and I think the committees here know, how much we've increased the number of diversion cases referred to diversion and other restorative justice programs over the last several years. And our state's attorneys, and we talk to them all the time, and they are doing this. They are diverting cases that you won't see on the numbers because they're not getting into the system. They are going to the alternative restorative justice programs. One of the problems we face now is that there are some, not all programs in each county are alike. And so they don't have the same resources. They don't have the same capabilities. And we're experiencing problems, there. I can tell you right now, our state's attorneys and deputies are handling average caseload of about 350 to 400 cases. And I assure you, I can tell you, I can bring every one of them in here and I can tell you that they're going to say, please don't give me any more cases. I don't want any more cases. I can't handle any more cases. So it's not as if we have people that are just, like they're begging to, have law enforcement come in, arrest somebody so we can prosecute them. That's not what's happening. We're dealing with situations where law enforcement comes to our office and they say, we've arrested this person for this, for this crime. And then we have to make the hard decision. Okay, do we charge it or we don't charge it? And if we don't do it, and if it's an active crime, again, we just can't turn our back to them. We can certainly try to get them into diversion and try to get them into restorative justice programs. But not all of the individuals who comply with that or want to participate. Tim was a prosecutor here in Washington County, and ask him, our Senator, Mr. Chair, if he could explain to you about some of the people that do come in and you offer diversion and you want them to go through it, but they repeatedly will not act and they will not participate.
Another question, William.
Yeah. Go ahead, Tim, and then.
Yeah, and so Tim Leaders, Dumont, and Department of State's attorneys. And so I did have a caseload that was over 300 the entire time I was a deputy, and you get used to it. It's just a part of what the job is right now. And you talk to victim advocates too, they have huge, caseloads of cases because every one of the cases with victims has victim advocates as well. But, John's right that there are certain cases, then believe me, I was the diversion liaison for Washington County. And you do see some folks come back through, and it doesn't mean they don't get another shot every time, or you have to make that decision. But there's an example that when I first started is someone that had a diversion referral in 2019. It took a while to figure out that individual was not going to engage with diversion, despite a lot of attempts, because the diversion staff, they reach out multiple times. I know some of you have active experience in this work, so I'm not trying to make multiple attempts to reach out. And then the victim might be very engaged with that process. Situation being a phone was taken, a purse was taken, so about $900,000 for diversion anyway. And the frustration, I think, comes in when it comes back to us. And despite all best efforts, a year and a half, 2 years later, right? And at that point, we make that decision about we're probably going to continue with the case. We move it in some way. In that situation, we got a restitution judgment order for the amount, and the case was, I believe, dismissed. But after we got the restitution judgment order, it took a lot of, it might have seemed like just a little misdemeanor case because actually there was some dispute about the amount of money. And restitution judgment order can sometimes be disputed. So there's another case that's going to be in the criminal court with a judge in the criminal division where important domestic violent cases aren't happening because we're doing this. So that was a successful story. It was a misdemeanor that took 3 years. And that's the type of work that I actually really appreciated, those misdemeanors that you handle with care, because every case is different. Oh, yes, sir.
No, I'm just going to have a couple questions, then we'll go to Barbara. Are you done, Tim? I didn't want to cut you off.
I'm happy to, I think deputy lots of stories, so happy to provide information.
So I guess backing up to what John was saying, so I'm not in any manner suggesting that that misdemeanors involving victims, restitution, or violence, or any of those things are just dismissed by fiat. It's like, but there are many types of cases. The cases I'm interested in understanding if they're part of the 13,000 misdemeanors that don't look like they're going to be handled anytime soon, and maybe taking away time from state's attorneys to do the domestic violence cases. How many of those, are there? Are there the drug possession cases? Drug possession case misdemeanors just should go away if they're clogging up the backlog and the dockets. VCRs should go away. Probably DLSs should go away, frankly. Maybe not retail theft, because we're hearing a lot about that, but there are categories of cases, and I don't understand what percentage of those 13,000 misdemeanors, over 13,000 misdemeanors and over 2,200 misdemeanors that have possibly been on conditions of release for over 2 years. That's what I would love to hear, and I don't want to have to get to the point of talking about separations of power and discretion and such. I would love to hear that the state's attorneys are going to take a serious look with the defenders, and maybe those cases are already gone. I don't know, but I would definitely like to see.
Good point, and I agree with you. Trust me, we have these conversations, and these things are being done. You don't see it all the time, but they are being done. We have the offices. For example, Rutland County right now is one of the biggest backlogs. We have a new state's attorney down there, and he is going through I've had conversations 3 times this week, and we're talking about, he's reviewing the cases that are older than 2 years, that are misdemeanors, that are what we would term generically as nonviolent, not that statutorily referred to as. Anyway, the point is that he's looking at those to see which ones. Are there a bunch of DLSs that can be dismissed? As you know, the legislature a few years back, we changed it because we had a backlog with the DLSs, because there were so many people with DLSs and that were becoming criminal actions. So now you have to have 5 or 6 operating under suspended license before you can get a DLS. So, and there's a lot of those, like, let's say with DLSs that are tied to some DUI cases as well. And so if you look at it just on paper, you go, wait a second, this is ridiculous. And then all of a sudden you start pulling string and say, well, let me ask you about this case. And they say, well, yeah, but here's, again, going back to the whole Harvey, is that the rest of the story is that there's more issues here. This is, this guy or person may be involved in another case. So we're doing it, but the other problem that to do this, because I asked another state's attorney, to do the same thing. They go, sure, you want to tell me when I have the time to do it? Because they've got, this one office had an average caseload of like 420. And I go, I'm trying to do all these other things. Do I have time to go through and look at all these cases that may have been handled by a previous state's attorney or a deputy? And then I've got to go through, I've got to find out, okay, is there a victim involved? And whatever. I'm not trying to make excuses, but it is one of those things that we are trying to do it. And so I think that we all have the same goal in mind, because as I said, our folks would love to be able to get some relief from the number of cases. 300 cases have an active caseload. That to me is just, I will say it's almost malpractice, because of the fact that you don't have the time to actually spend trying to find justice. And justice is what our job really is. It's not to put people in jail, it's to make sure there's justice across the board. And so we're faced with a really tough task of, there's so many cases out there. And one of the other issues is that you looked at, there was 40 jury trials. Well, we don't have the same number of courthouses you'll find, let's say, in other jurisdictions. They have more judges, they have more courthouses. And without those resources, you can only do so much. And so that is a problem. But I can tell you that we are taking it very seriously. We are trying to address the issues. And that I can tell you almost every, in fact, I can tell you every one of the essays realized this is a problem. I will go back, and I've talked to Senator Sears about this. I'm going back when we have our meeting with all of our essays, I believe in 2 weeks. And this was going to be the #1 topic, and to figure out is there any way to actually look at and say, make a policy that X, Y, and Z cases can be dismissed. I'm sure I know what the answer is going to be, and they're going to say the same thing I just said, is that you can't make a blanket policy when you're dealing with individual cases, individual victims, individual crimes. It's going to be really tough, and then especially with such limited resources.
Right, thank you. I know Barbara and then Karen had questions here.
So I'm wondering if you are able to get us a list of which areas aren't served by diversion programs that don't exist for those counties so that we can look into that, as well as which districts aren't making referrals to programs that do exist. Because my understanding was that was happening, and maybe my information is old. So I just want to sort of get the up-to-date information on use of diversion programs. And when we heard from our Attorney General yesterday, one thing that they made clear is that they have resources to offer in terms of tough cases, helping with prosecutions. And I'm just wondering how often state attorneys take it. Like, I don't know if they're booked up, but like making sure that if that adds to the bench strength, that we're utilizing that resource.
The criminal division of the AG's office has been, Domenica Padula has done a great job, and she's there helping out in some cases, but they do not take just any cases. So
sure.
They would take specific cases, and we do take advantage of that. They have concurrent jurisdiction. However, it is not, they're not going to take misdemeanor cases.
No.
You know, so.
Sure.
I wouldn't expect them to. And as far as the other numbers, as far as ones that people are not referring people, I don't know of anyone representative that any office is not doing that. Willa Farrell from the AG's office, she would be able to give you specific information. And I believe she just did a report for, I think it was for a legislative. I wanted to speak with her.
I can send that to you, Representative.
Thank you.
Tanya?
Thank you. Mine is actually a little bit of a follow-up, so thanks for teeing that up for me, Representative Rachelson. In your view, what are the investments we can make in the community justice centers and restorative justice centers to build equity across our system and create more access to those services?
You know, I don't, in fact, it's interesting because I just received this email yesterday from one of the other offices, and they said that they are looking for doing direct referrals to one of the CJC programs, but this is what he says, unfortunately, we lost some momentum on that project when their last manager left. So it seems like there's issues within the CJCs. I can't speak to that because I don't know where all their resources come from. I do know that not all diversion programs or restorative justice programs are the same. Like Chittenden County, you all have some really good programs, but that's not the same over up in the Northeast Kingdom or over in, but you may be in St. Johnsbury, but Orange County, they don't have them. And that's what, when we talk about disparity, justice is really disparity of resources quite often. And if I could just also touch upon that for a second, is that I hope you understand, we don't, as prosecutors, we don't work in a vacuum. When we go to court, there's a defense attorney, there's the court. We all have to be part of what happens with or how a case is handled or how it's resolved. So we try to work together. There are situations where, yes, there are some state's attorneys who go to the defense bar for a number of reasons, which is unfortunate. We try to say, look, you have to put personal animus aside and get some work done. But and it's the same thing where we've seen in the pandemic. There's a lot of defendants, of course, have asked for jury trials, and because if I was a defense attorney, I'd probably say, hey, your option is to get a jury trial, and you're not going to get a jury trial for a long time. And then, defendant says, well, if I wait long enough, maybe the witnesses aren't, something will happen to them. Not that they would do anything to the witnesses, but they might, leave, move to another state or whatever. So the chances of their case being dismissed later on are better. So I guess that's what I'm trying to say, is that the system is one in which we have the prosecution, we have the defense, we have the court. We are working together, as Judge Zone had said, to try to work something out. Matt Valerio has been really good. We talk with Matt on a regular basis, and we agree far more than what people would think. And it's just the fact of trying to get it working and try to actually get it pulled off.
Yeah, and I think that's what I'm trying to get at and trying to get a sense of is that you don't work in a vacuum, and so much of what you can do within a particular place is largely dependent on community resources. And while I think it's incredibly important that we invest the resources in the state's attorneys and the judiciary that are needed, I think it's also really important to talk about the community resources that help people keep people out of the system and help divert people from needing to be there in the first place.
So I would love to have more resources put to try to prevent them coming into the system to begin with. It's just like a highway. You know, you got transportation, you build a highway, you know, we have it like our interstate's 4 lanes, you know, and the more cars that keep on coming in, then what are we going to do? We can't, you know, there's not enough room to, you know, to have that many vehicles on the road. So we're going to just say, okay, any vehicle that was made before 1980 is no longer able to go on there. And I'd rather do something to suggest that they may try alternative transportation, such as, you know, buses or trains or whatever. But here, I just think that if you look at some of the folks that are involved in the system, and find out what's really driving them. And there's some of them that are the same people over and over and over again. And Senator Sears knows this with generational, where you see the same families coming into the system. And if they're coming into the system, we're failing them somehow. So what are we going to do to try to prevent that, so that there aren't any victims or victims, you know, that it's greatly reduced? I mean, we need to start looking there. And you know, unfortunately, with the rise in the opiate and the you know, now with fentanyl and what's coming is meth, it's gonna be worse. And these are the good people, I mean, coming from good families, and yet when they get caught up in this, they, you know, there happens sometimes they end up, you know, committing property crimes when they're doing things that they normally wouldn't do under the influence. They're causing, you know, they're hurting people. So. You know, I'm not making excuses for people, but I also am saying that I think we should probably look to see what the source of the problem is. And let us, there's nothing more that I would like than having our state's attorneys have no work. Simple as that.
Karen had a question?
Yes, thank you for this update. It's really helpful to hear how your office is working on all the areas that you can. And I think that's part of the work that we're doing, is trying to have that assurance, right? We know there's an issue. We want to know, are you doing all the things that you can be doing? So it's helpful to hear this. I appreciate that example with the CJC and restorative justice, because I feel like that reinforces the thing I'm curious about is these written policies. Because I feel like what I've heard is it's not across the board in every county that state's attorneys have written policies on topics such as utilizing the community justice center, using pre-charge, dismissing, whatever it might be. And I realize that that can be a pain, right, to create all these written policies. But that also provides a layer of assurance for us that things are being done a certain way, and there is geographic equity and things are being done. And so I'm realizing is like it could be hard to get that perfect written policy, but is there something to start with in each county on some of those topics? Like I'm thinking with the CJC one, if there is a written policy, that policy is there regardless of who the CJC staff person is. You at least have a foundation, a starting point. And that's something that I'm feeling like we've had a lot of lessons learned in the past few years. It would be very helpful to know that each state attorney's office has this guiding document of how they're moving forward.
Yeah, and you know, it's one of those situations that I'm not about trying to make excuses here, but it's if everything was equal, you're right, that would be great to do. But you know, when you look at these cases when they come in, and by the way, I welcome any of you here. If you all would like to, you know, to visit one of the offices or to meet with the SAs or DSAs, please let me know and we'll make sure it happens. But if you're not all the same, so one comes in and you go, all right, I know that the people at this CJC are left and we don't really have we just have a person who was really, let's say, doing the books for them or something. That person that we have now is not going to get that type of help. So where else can we do? We have a lot of programs, especially down in Windham County, where our state's attorney has alternate programs that they go to, and they've been very successful. But they're not your CJC, or they're not your diversion. They're outside of outside of the normal group. It's just a community-based issue. So, some of the cases are, you'd like to be able to fit them all into one, into that kind of one slot, but there's just so many variables in each case that it's hard to do that.
And I guess I'd push back a little bit with it of seeing some states attorneys do have written policies. So how can we build from that and learn from that? Like not have the perfect policy, but have a starting point.
And again, it's each individual office, and I'm sure there are some of the offices that do have policies, and again, I think I know which county you're referring to, and they are also one of the counties that have more resources than anybody else. So it's easier to, come up with again, when you have uniformity and when you have something you can rely on a consistent basis. Because to me, there's nothing worse than setting somebody up for failure. So if we send somebody to a program that's worthless, or that, that somebody, they're not going to get that same kind of assistance, that's one of those difficult things for our folks.
Go ahead.
My question, I think, is a follow-up to that, and I appreciate your highway analogy. And in that case, the last thing I would want to do is for us to just add a third lane, to a fifth and sixth lane.
I know, this would be like Florida, yeah.
Yeah, and also it's not really addressing the problem. So if what I'm about to say would be the equivalent of that, tell me. But building on what Representative Dolan was saying, would the entire system benefit from a more formalized, like, diversion, restorative justice? I had to use the word department,
No, I know what you're saying. And the answer is, I think we've already been doing that. Like, we started this 4 years ago where it was like pushing the departments, like, come on, you guys got a diversion program. So that's when Willa Farrell came in and started gathering the data. So I think we're doing that, and it's just right now it's still, even though 4 years you think it should be done, it's still, as Will, I tell you, they're still trying to gather enough data to actually say, is this really working correctly, or is this making a difference? But again, I'd say if you are looking to force a geographical, to take all the disparity out, it's, as I said, it goes across the board. So it's not just the state's attorneys, but it's also the defender generals or the defense attorneys. It's the court, because again, the court, as Judge Zone had pointed out, is they have authority under Rule 48 to dismiss cases in the interest of justice. So, and this was done up in Franklin County. Unfortunately, you have judges they're not elected, thankfully, but they are appointed and they have to go up for retention every 6 years. Then you have elected state's attorneys, and you have the public defenders don't figure as much in it, but your elected officials, when you have a county, and if you just all of a sudden do a mass dismissal of things yourself, and you have all these victims out there asking why their cases were just thrown out, then they're facing that same political pressure that you guys are very familiar with. So, and the judges also, I think, feel the same way. I think, and again, Judge Zone kind of alluded to this, we've been meeting the group, and I think that we're going to see probably more action, more activity that's going to be similar to what happened in Franklin County regarding if we're able to identify some of these cases that, again, I like to say victimless, or where the victim is bought into it and they are able to agree. I think then you're going to see that's probably more what we consider a bolder move. But it takes time to be able to figure out, to review all the cases, to get everybody on board. So hopefully that speaks to that.
It does, and it makes me wonder what you might have to say about a larger, broader, sounds like in some ways to create the circumstances in which a bold move such as that seems feasible, and then is because I appreciate that you're referring often to the victims and their need for justice and a sense of justice. So what would you say to, if I'm thinking about the larger cultural shift, perhaps that is necessary to, and you were mentioning the number of folks who don't elect to participate in the restorative process. Where could that kind of education come from, and would the system benefit from that? Would our communities benefit from that, and where would it come from? To help folks understand why it looks like that might be the right thing to do.
It's the same thing like with drug court and the treatment courts, which I support, and I think that they work, they're great. But when you have people in there that have, and unfortunately, some people just don't want treatment, and they don't want to involve themselves, and it's like, people talk about homeless people, and they'll say, people go, oh, I can't believe that person, why, they should be, they don't want to stay out there. No, there are some people who feel far more comfortable out there. Not that I want to see that, but you'd like to be able to have programs or help folks that are not able to help themselves. But when you can't force certain people to do things, and treatment, I think, is probably one of the biggest. You can't force someone into treatment. And it's got to be, you got to have the right resources there, the right treatment available. Anybody, if you can just we just start hanging up shingles and saying, come on here, we'll try to help out, be a restorative program. You need people who are professionals, at least I believe, to do this. And it's not really, I shouldn't even be answering this because I don't know what resources are available, or if they're having problems finding folks. I know we have problems trying to find attorneys, and that's across the board. But
can I just maybe help out here a little bit?
Thanks.
Part of the problem is timing, and people are willing to accept help at certain times, and at others they're not. And was just recently made aware of a case in Bennington where a woman waited 3 weeks to get into Valley Vista. They had a deal, they had the room, and the day that she was supposed to go there, the person from the Turning Point Club gets a call. Sorry, the bed is not available. That woman's now disappeared. She's no longer amenable to treatment. So I think a lot of it has to do with availability of the services. And when we've got a backlog, and people are out there for a long time before that actual forced, you have to make a decision. Do you want to suffer this consequence, or do you want to go to the treatment option, whatever? I think that's part of our problem. And we haven't really looked at particularly as a result of the pandemic, the lack of resources that are available when people are actually amenable to treatment. And then we say, well, they weren't amenable to treatment, but that woman who waited 3 weeks, that was as long as she could stay sober, I guess.
I couldn't agree with you more. That happens all the time. It's the same thing. Like if you get people in arraignment, that's when they feel like that they got to have like that case of the yucks. Like, oh my God, I can't believe I did this last night. I either drugs or drinking, whatever. And so they find themselves in court. If they're offered, you get them right then into work. I guarantee, I shouldn't guarantee this, but I would assume that you're going to have a far.
I think the important question for us to be asking of particularly the Agency of Human Services is, what is the availability of treatment on demand?
Yeah.
And is it geographically available? And if it's not, what can we do to deal with that problem? The backlog itself creates that paradox where I don't have to face up to my problem right away because I'm out on release and blah, blah, blah. But I just a thought that in terms of some of the solution to this problem lies in the availability of treatment.
And I think that helps along with the prevention, where you get them out of the system and then they're more willing to stay out of the system and not commit. So
Ken had a question, I believe.
Hi, John.
Hey, Ken.
Good. How are you? It was mentioned earlier about individuals in multiple dockets. How much of this backlog is driven by the same individuals that are showing up in different dockets?
I can't give you the exact, but I believe we should, hopefully maybe with the court, we could probably get that number. But I would assume, and maybe I'm wrong to assume, what they say, but I would think that just anecdotally, a lot. Because just from the stories I hear from the different state's attorneys, again, not just the same individual, but like same, families sometimes are involved with brothers, sisters, and siblings. So, but I think that's a great stat to look for. So, and Judge Zone is back, and Terry are back there saying, shaking their heads, yes. So they're able to answer that.
Well, and one thing I'll just note about the individuals in multiple dockets, that someone may appear, so if you're doing, and I'm not saying this to get a rise, but if you wipe out someone's DLS, or they were not willing to engage with diversion, or something that we can't deal with, they can't afford to get their license back, right? That's in Vermont, everyone needs to drive. So that's sort of a societal issue that often comes up and faces our deputy state attorneys right in the face. This person needs diversion, but we're hearing from the diversion folks that they can't afford to get back on their feet, and that's such a difficult space. So sometimes some deputies have dismissed those cases anyway, and we know we're going to see them again. Right. And that's just a cultural thing that's happening. But I want to note that you might see a 2019 DLS and you'd be like, what the heck is that? But that person might have 4 pending DUIs. And so if you wipe out the 2019 DLS, not that it's needed, but that is sometimes pressure that the docket that someone is facing to engage with consequences, the more serious conduct. And, I had there was a DUI that resolved as a neg-off here in the Montpelier area where someone spilled stuff all over the road. It was a very serious case. There happened to be no victims, but it could have been tremendously fatal. And that individual had quite a few DLSs, opportunities with diversion, in fact, and the DUI did resolve. But it was that cumulative individual, as you see in the docket sheet, for that person might have been quite long. And the diversion opportunities were still happening. Sometimes judges and certainly prosecutors have some hesitation about referring someone to diversion for DLS, sort of with conduct or simple assault, when they have a more serious thing happening in their life, like a pending major felony too, or a series of failed diversions. Sometimes the judge will bring you to the bench bar and say, hey, this person has failed from diversion 8 times. Should we just proceed with the arraignment? And so I know I've gotten those when I was just starting out, where I was just using the statute to say, let's divert, and then seeing that the full picture might be more complicated. Just as a.
Kind of had another question.
It's almost like you knew exactly where I was going with my next one. So didn't we do a DLS amnesty or whatever it's called years ago?
Yeah.
And to try to get more people back on the road quicker and all that stuff and help out with that. And wasn't it like a really, really low cost fee, because obviously they need to be working, they need, to get to their job and everything, to pay their fines and add back to society. How did that work out?
Depends on who you talk to, I guess. Is Eric still? Eric, did you do that? Well, remember we did it? I was in Judiciary. I remember that. Yeah. Senator Sears, it was like one of his babies and it was, to try to get people back, because as Tim mentioned, here comes Senator Sears. As Tim mentioned, you have people who they have a DLS. Not only is their insurance outrageously costly, but they have the other financial. So, Senator Sears, if you don't mind, I'm going to pose this question to you, because Representative Goslin had asked about, remember when we were back several years ago when we did the change for the DLSs that instead of them becoming criminal, what was the matrix of that? How I'm trying to think. Did we just say it was like the 7th? You had to have like the 7th, 6th, yeah. So that'd be your 6th DLS in order to be charged criminally. So the ones that you see here have all had.
We spent quite a bit of time on helping people with solutions through diversion programs.
Right.
To getting off of it, so that they weren't just, they were able to go to work and drive for that and so forth. So, but, it's still a problem. I mean, at one point there was 67,000 people with suspended licenses in Vermont.
I think we have a mere 35,000 people now still.
Well, that's real progress.
It is.
Are they, well, yeah.
Yeah.
So I believe there's a bill out there, or it's coming, or something that's being talked about, and this is something that I really think we really need to look at and figure out a way to deal with that. A lot of things that I'm hearing in this room this morning, it affects, it's not just the judiciary, it's any of us that are in business and everything. We have all had these same problems. And it, obviously, COVID and the amount of time taken off and so many people leaving and all that stuff, it just.
We'll also look at the fact that some of these people are your employees that, you know, if they don't have, they can't drive, then they can't get to work. So people are forced in a lot of situations to drive, even with their license suspended, because they're willing to take a chance that they might get, you know, another DLS, and it's really unfortunate.
Yeah.
But it's like a spiral, and, you know, you got so much weighing over you that you don't have any other options. You know, maybe the thing is to look at saying, let's find out, talk to the people, because we're talking to one of the people of DLSs, but, you know, there's got to be some way to where you bring those folks in that have had problems, and if it's just a matter of you know, getting the actual license back, it's not like they're still, you know, involved in, like with DUI or, you know, driving under.
A surprisingly high number of people never had a license.
I'm sorry?
A surprisingly high number of people never had a license to get suspended. So they were driving without a license, but they never bothered to get one. So that is also, I think, in that group.
Yeah.
But it's a little different than license suspended because.
One of the things might be interesting, Judge Zoney, I don't know if you mentioned it in your, yesterday or the other day when we were talking, we talked about what the top 5 misdemeanors. Do you have that?
It wasn't on the lines of what we were.
Yeah, right, exactly.
He's turned back to his Senate days and questioning.
I'm sorry. And the pro tem does it, you know, I don't want to involve everybody.
The answer is yes, I have it, but I've got to get my Surface Pro back up.
Uh-oh, it's the fault of IT.
But it's just that I think it might be an interesting statistic for y'all to hear. I think it was like simple assault, DLS.
I do have it here, Your Honor.
Violations of conditions.
So I think the top 5 were DUI, all types of misdemeanor DUI, such as, not the multiples, 1955. So VCRs, the violation of conditions of release, 1821. Domestic assault, these are misdemeanor domestic assaults, 1598. Vehicle operation while suspended, we're just talking about 1186, and then simple assault, 990.
Could you send us that information, and also a trend particularly with respect to the VCRs? Because if we have more people on VCRs for multiple years, it would seem that there's more chance to violate.
And again, those are the VCRs, because we talked about that, and actually Matt will probably tell you in a second, is that, you know, he sees that the violations, conditions of release are, you know, probably the largest, you know, problem area. But I would just say that when you take a look at it, I would ask you to make sure to look at, you know, understand that there are individual cases, and a lot of these times there are people that are victims involved. They're, you know, victims of domestic violence, and if you decided that we're just going to do, you know, try to kind of give a sale day for anybody with a violation, then you're really hurting people who have already been hurt before. And so I would just ask that you take that into consideration.
Last question to Kate.
I actually have a comment, if that's if that's okay. It's sitting uncomfortably in my stomach, so I feel the need to say something. Earlier, you were referring to folks who might be committing certain acts because of addiction, and you said some of them come from good families, and it felt uncomfortable to me. I think as we're talking about access to justice and we're talking about really complex issues and who's in our court system. I just want to make really sure that we don't frame people or families in terms of good or bad. These are humans and we all deserve access to justice.
I couldn't agree with you more.
Thank you.
And so what I was referring to when I said that is that because I get tired when I hear people tell me, oh, they're just a bunch of dirtbags. This is the people involved. That's not true. I mean, I've got friends, I've got family, I have a nephew who committed suicide because of his drug addiction. So I understand, and it's not everybody, it doesn't choose who it attacks and who become victim to it. So I share your feeling about that. So if my comment was in any way taken that way, then it was not meant to be.
Thank you. I appreciate that.
Anything else for John or Tim? Tim, nice to see you in a new position, new role, and I'm sure we'll see more of you.
Thank you, Mr. Chairman. Committee members, thank you.
Thank you, Annie, for your help.
That's good.
Matt Valerio, you're next. Morning, Matt.
Morning. You hear me okay?
Yep.
I am actually here in Montpelier. And for those who don't know me, I'm Matt Valerio. I'm the Defender General and have been for quite some time. I am actually here in Montpelier and was making my way over to the pavilion this morning. And apparently BGS changed the coding on their security things. And so I got trapped in the tunnel, which is always fun. And ultimately I was able to escape, but did come back to my office and signed on. And I really wanted to be there in person today. And I probably could have got there given the length of some of the testimony, but nevertheless, here I am. I've heard everything that went on, and I appreciate you having me here. Of course, and I know that you all do this. Interrupt any time along the way, and I'll answer whatever I can. Of course, the backlog that we're dealing with is pretty much unprecedented. I've been a lawyer in Vermont for 34 years, and I've never seen anything like this. On occasion we've had times where civil jury trials were suspended for a period of time, and that caused a backlog in the 90s. But never had I seen anything like this. I'm going to use what Judge Zone and Terry Corsones and others have given you as far as statistics as sort of the backdrop to the bigger picture, or that's the kind of the bigger picture. Public defense is a significant subset of those statistics. Proportionally, we are looking at pretty much the same sort of thing that the court is. Just for those who don't know or who are new to the judiciary committees, and I was hoping I might get a chance at some point to come and talk to, in general terms, to the House Judiciary Committee about the DG structure and how we allocate caseload and that sort of thing. But in general, the Defender General's office handles somewhat north of 85% of the total cases that are in criminal court. There's about 10% of people who are don't qualify for public defenders because they aren't looking at probation, jail time, or a fine over $1,000. In that 10% as well are individuals who decide they don't want a lawyer and they want to represent themselves. And then there's probably 5% that are represented by private counsel. So if you look at the percentage of people represented by lawyers in criminal court, it's somewhat over 90% are represented by the public defense system, either by staff offices, contract offices, or some of our various conflict offices, serious felony units, or caseload relief offices around the state. I think that Senator Sears asked a good question to review regarding the so-called COVID relief funds and ARPA funds that came in from the feds and how the Defender General's office has handled dealing with those funds. We had a plan that was submitted, and we have basically kept with that plan, except for where we couldn't keep with that plan. The first thing that we did with that money is to get all of our contractors and staff offices up to speed technologically so that they could access the courts remotely during the pendency of the state of emergency and the kind of the height of the pandemic. That really did take place within the first couple of months of getting that money available to us. And the second thing that we did that remains in place is to contract with what I call caseload relief contractors around the state to deal with the growing backlog of cases that was coming out of the staff offices. And we spent about $800,000 doing that in the first year. We're spending about $800,000 a year. Two things were happening in the criminal arena. Of course, there were no jury trials. And during the majority of the pandemic, there were few contested evidentiary hearings in criminal cases. Not to say there were none, but it was not nearly the number that you would normally have. Those things that push cases toward resolution. One of the big areas that effectively stalled, and I think next to no progress was made at, was DUI cases, including civil suspensions. Now, one of the reasons for that is and I'm not saying any of this was right or wrong, I'm just giving you a reason, is that civil suspension hearings were effectively, in DUI cases, were basically stayed. And as a result, people didn't lose their licenses right away. And as a result, because there were no trials and there were no civil suspension hearings, the DUI pending caseload blew up. And we are seeing that now, where you would note in the court's data, and my data is also showing that DUI is one of our top pending misdemeanors. To be clear, the Public Defense Office doesn't do civil suspension hearings. All we have is the criminal side of it. So when a client sees that the longer this goes on, the less, I'm not losing my license, and that's a good thing for me. They're not going to enter a plea or resolve a case. And so you've got a lot of DUIs hanging on out there. In the meantime, there were still criminal cases coming into the system. Some counties saw a significant decrease in law enforcement activity. And so while the cases were coming in, they were really the very most serious, and a lot of the lower end cases were either being sent elsewhere, they were not being prosecuted, they were being handled in some other way other than being filed in criminal court. But other counties seemed to have law enforcement activity going on as though we were doing business as usual. And those counties, for us, and I'm sure for the state's attorneys, tend to be more problematic. When the system is presented with a case by law enforcement, prosecutors have a decision about whether or not they're going to bring it, but that discretion is, it's to some degree limited by law. Ultimately, if the case is filed and it ends up qualifying for public defense system has no discretion not to take the case. So it's there, and for better or worse, it is subject to all of the, rising and falling tides that you see with with caseload. And in this case, you know, we saw a rising of those tides. Effectively, although I know throughout the system, after a period of time, the defense bar started filing lots of dismissals for speedy trial purposes. There was very little progress in that. I was actually surprised that more progress in getting cases dismissed did not occur. It just didn't occur as a result of speedy trial. There were always, you know, there were decisions that the court made, and you know, there were a few that were dismissed, but relative to our total case load, it was minuscule. The way the courts are handling cases, and appropriately according to statute and constitutionally, is the chins and termination of parental rights cases, which the Defender General's office handles 100% of, pretty much. You know, it might be 99.8%, but call it 100%, are the highest priority for the court. Incarcerated felonies would get the next priority for jury trials, and then misdemeanors would be kind of taking up the, you know, the back of the line. We are in a situation now where I think if nothing is done to try to resolve these backlogs, you're going to see at some point misdemeanors that are 7 years old, 10 years old by the time you get to them. And, you know, that poses a lot of issues, you know, for the system. And I don't want to get too far into the weeds, but it causes a caseload management issue for the Defender General's office and for the public defense system as a whole. And try to follow me on this, because it's a little bit, like I said, it's a little bit in the weeds. The DG's office can take a staff office, primary public defense office, can take cases in, and once they're arraigned, there are witnesses and there might be co-defendants and the like in those cases. And so you end up with, for co-defendants, they require conflict counsel. Sometimes you have 2 or 3, sometimes more than that. But while a case is pending, the analysis of whether or not there's a conflict of interest in the public defense system is done under one of the rules that is it's the current client analysis. And while a case is pending, the public defense system can't take another case that would conflict with a current client's interests. As a result, those new cases that might come in, could be a different defendant completely, all have to get pushed into the conflict contract system that we have. If a case that came in and was being moved, the public defense system would analyze that conflict under the quote, former client analysis under the rules of professional responsibility. That allows the public defense system at the first level to take cases that it would not be able to take if the prior case was a pending current client. So what is happening is we have a lot of cases because of the backlog that are bypassing the first level of public defense and putting extraordinary pressure on the conflict system. These issues arise a lot in multi-person drug raids and the like, and we are seeing huge pressure in Bennington County, particularly, and to a little bit lesser degree in Windham County, where we have seen lots of multi-defendant drug cases coming into the system without being able to be resolved because of their place in the pecking order regarding the dispositional priority. So the backlog creates institutional pressures that didn't exist, that go far beyond whether or not a case is old. It goes to the resources necessary to actually deal with the conflict cases. Now, one of the things I think the committees, some who've been on the judiciary committees for a long time, would know this, and others who are new may not. Lawyers don't make plea agreements. They propose plea agreements to clients, and clients are the sole determiners of whether or not to change their plea. A lawyer cannot tell a client that you must change your plea. And there are a number of other issues constitutionally that are the sole purview of the client. But I think one of the things you're seeing is that when clients see that they cannot be convicted because there are no trials or are no substantive hearings, particularly if they're released on condition, there's little or no incentive to resolve a case by plea. As I talked about a little bit earlier, the DUI cases and the staying of the civil suspension of licenses allowed people to keep their licenses much longer. And so now, we have DUI being one of our top 5 pending misdemeanors when it used to, frankly, not be. The number one things we used to deal with are violations of conditions of release, driving with license suspended, domestic assault, simple assault were pretty much the highest ones, but the far and away the top couple were DLS and violation of conditions of release. Of course, one of the things you see when a case is pending with conditions of release, the longer it's pending, the more likely you're going to get a violation of condition of release. And so the 2 areas that have gone right through the roof with it, as far as pending misdemeanors, are violation of conditions of release and the DUI cases. DLS, which always was our number 1, has dropped to a distant third for public defense. Now, to be clear, again, public defenders don't handle civil license suspension hearings unless there's a crossover issue. And I mean by that there might be a suppression issue, bad stop, bad test, or something that would result in officer's bad processing, whatever it might be. And those are, in the grand scheme of things, relatively small. So you've got these civil suspension cases hanging out there with a bunch of pro se, unrepresented people, and then you've got the DUIs that have come into the public defense system when in the past they wouldn't have been. One of the things that we're dealing with, so I talked about the conflict issue and that pressure on the system as a whole. I talked about when cases are pending, you get more VCRs. One of the things we're seeing, to be honest, is that the clients just disappear. There are many who are arraigned between 2018 and the present, and particularly through 2022, who have just dropped off the map. I don't know if they understand that their cases are done, or they just don't care, or it's just taken so long. A lot of these folks are kind of living on the edge anyway. They move around a lot. They don't have, fixed residences. But we don't know where they are. And that is going to be a huge issue going forward, where we aren't even going to be able to locate, as time goes by, particularly many of the minor cases, basically the misdemeanors. As part of the plan to address the issues that gave rise to the pandemic, and now obviously dealing with the backlog. The Defender General's office had a plan to hire limited service positions, support positions, not attorneys, because I could deal with the attorneys by contract. One of the things we found is the same thing that we ended up finding over the last period of years, is that the job market is such that I just can't hire people. In rural areas, the lawyers don't exist. In the more populated areas in Vermont, the offers are not competitive with what the private sector is offering. People in all over the state have, I'm sure, noted that there are plenty of good paying options for work in the private sector that can't find people to work for them. Marshall Paul, who was my deputy, was telling me how his daughter's salary at making pizza went from $11 to $20 an hour plus tips. And, you know, the administrative services positions that we have in the Defender General's office start in the $15 to $16 an hour range. So if you can make pizza at $20 an hour, that might be a better option. We did advertise these limited service positions consistent with the state pay plans, and we literally received no applicants for 9 months. So what I did is I repurposed the funds to contract with more caseload relief attorneys. The good thing about those caseload relief attorneys is they were able to effectively babysit cases during the couple of year period where we were in a state of emergency. The downside is that we were not able to do trials during that period of time. And so, in my view, we weren't getting the biggest bang for our buck. Like if I had if things were normal and normal time frame and we had the ability to do trials, those positions, those caseload relief attorneys would have disposed of hundreds and hundreds of cases over the counties. One of the things that we are finding in the DG system as a whole, and this impacts the backlog just from an operational standpoint, is the lawyers in our system are aging. We don't have a lot of new blood coming in. In the last year, I've lost attorneys to death and illness, brain tumors, retirements, leaving the practice of law completely. Thankfully, not dying or illness, but you know, serious felony unit contractors have quit. 20-year contractors have quit. We've had retirements, and the problem is we really don't have a bench. There are very few young lawyers coming into Vermont. Vermont Law School produces very few lawyers for Vermont. And, you know, Vermont is based on, really on pay, is not a destination to practice law. Some of you have heard me tell the story of, you know, and some of you have not, of my niece who was a good student who, but grew up in Vermont, went to Holy Cross in Massachusetts College, and was a good student there, but not like first in her class, but good student. Went on to law school at Catholic University in DC, again, good student, but not number one in her class. And she came out of law school and took a job she took a job in Boston, starting salary of $200,000 a year, plus $10,000 to move, plus $40,000 bonus if you stay for 6 months. And that doesn't count your bonus at the end of the year. So she's basically in the range of $250,000 to $300,000 right out of law school, having not practiced a day in her life. And I'm not saying that those pay is the type of pay we need in Vermont, but that is what our competition is. Because we're trying to attract lawyers from out of state, ones who go to law schools in Massachusetts and New York and Connecticut, and in the surrounding Northeast. And if the market is commanding that for a above average, but not preeminent student, then we're at a significant disadvantage as far as getting people on the ground to do the work. And so I see this as a collateral issue going forward. Right now, we have some openings, particularly in our contract system, that I haven't yet been able to figure out how to deal with. But as we work through this backlog, and frankly, we burn people out doing this, our ability to attract people is going to be impacted significantly. I think that the one message of hope that I can give to you is right now, if we can get cases into court for the hearings that they need to have, we are in a position in general to be able to handle that work. Our pending caseload has more than doubled compared to what we had before the pandemic. Before the pandemic, the average pending caseload for a public defender was somewhere in the 75 to 120 pending case range. That is now in the 150 to 250 range. There was one county, Lamoille County, to be frank, was one where we had one attorney there. It had always been one of those, it was our staff attorney, one of those counties that was handled pretty easily by an experienced individual attorney. Then there are obviously conflict attorneys as well. And during the pandemic, cases seemed to come in somewhat regularly and were arraigned and then just sat there, and about 2 months ago came to realize that there was a pending caseload of 600 cases for one lawyer. And so I put 2 more contracts in place there and brought that down to kind of where we are on average, which is about the 190 to 200 range. And once cases start moving, then we'll be able to, work on that. But, when we're talking about misdemeanors, because of the priority of other cases, the juvenile cases and the incarcerated folks and felonies, if something is not done to address those, you're going to be talking about very ancient looking misdemeanor cases at some point.
So, Matt, yeah, thank you. I think we're going to be losing people in about 8 minutes. People have to go to other meetings.
Understood.
Could you tell us some of the ideas that you would have that we need to look at for addressing the situation that we find ourselves in? And I'm certainly hearing some hints from your testimony that more resources, like higher pay so we can actually attract some attorneys. But what are some of the other ideas that you would want us to consider?
Well, I'm not sure that, even forgetting about that resource issue, I am not convinced, honestly, that higher pay is even going to attract the attorneys. I know that it won't hurt. One of the things that is a big issue is that our contract attorneys don't qualify for loan forgiveness, where our staff attorneys do. There's federal loan forgiveness, 2 different types of federal loan forgiveness. I think that I don't know the answer to this question. If dismissing swaths of misdemeanors where they are so-called victimless crimes, we've had discussions about violations of conditions of release where the violation isn't a new crime, or DLS. And by the way, DLS is something that is not necessarily near and dear to my heart, but unfortunately, over my 22 years as Defender General, I've been on 4 study committees involving DLS. And one of the things we've pretty much learned is no matter what you do, nothing changes.
That's the good news.
Yeah, well, the 67,000 that Senator Sears was referring to was the total number of suspensions that were issued. There were some dead people in that group, as I recall. But these suspensions that we were looking at were not suspensions that were the result of DUI. These were the vast majority of them, 92%, were for failure to pay fines and points. So it ended up being a poverty issue. And we've done a number of things. We at one point we wiped out all DLSs, so nobody had a DLS anymore. And within 3 years, the numbers came back to right where they were. Then we did the thing with the 6 DUIs, or it's not 6 DUIs, 6 DLSs that before it became a criminal thing. The bottom line is that the number of actual Vermont DLSs didn't change significantly no matter what we did over that period of time. And they tend to be a kind of a time suck for all of us in the system, in the courts, the courts, the prosecutors, defenders work while these cases are pending to try to get them reinstated. TJ Donovan, when he was state's attorney, and then later when he was AG, had various programs to, bring me $20 and we'll get you reinstated. Some of those amnesty programs, it hasn't significantly changed anything. So I don't know what to do with DLS, but I do know that as part of the bigger picture of the backlog, it's not something that we would really prefer to be dealing with, given the important and serious cases that are out there. Violations of conditions of release has always been an issue in our system. It tended to be the biggest misdemeanor that we dealt with. The vast majority of those violations don't involve new crimes. And I've made proposals in the past for a statute to be passed that says that would basically say, unless a violation was a new crime in and of itself, that the violation should be considered at the time of sentencing as opposed to a new docket number. So it would be a sentencing consideration instead of a new case that we would all have to deal with. I think that some of those cases are appropriate to go away where there are no victim issues involved. I also think that it's the kind of thing where maybe if you looked at DUIs that had a test 0.10, I'm just throwing ideas out there, okay? 0.10 or less, there was no accident, no property damage, and there was no personal injury. Maybe those cases are cases that would be appropriate to get off the docket in one way or the other, either by deferred sentence or by, I guess, dismissal. I know that there are interest groups that don't like that idea, and I'm sure you'll hear from them. We have the issue of retail theft. Oddly enough, you hear a bunch of concerns about this from vendors. Our numbers in retail theft are not really up. That's not one of the areas where we have a huge increase, nor is it a huge part of the backlog. DUI, we have, I took a snapshot yesterday, 2,527 DUIs, 2,240 violations of conditions of release, 1,000 or basically 1,100 DLS cases. Retail theft is 500 cases. It really hasn't, that's not where our biggest problems are. So, I think that you've got to look at the low-hanging fruit of cases that have not caused severe damage to society and decide whether or not these is where we want to put our resources of the criminal justice system. And I understand that everybody has an interest one way or the other in these cases. But I would hate to see, down the road, us having to try, or even litigate or consider, 6, 7, 8-year-old DLS cases.
Right, appreciate that.
I have, Matt, will hopefully see you soon on bills and Senate Judiciary.
Yeah.
You're absolutely right about DLS. I'm going to age myself. I started working with Peg Flory on that when she was chair of House Judiciary. You may remember our
I was here.
first stab at it. And says a lot about where we're at, but we keep trying.
Yeah.
I'm glad the House is going to take it up.
Yeah, we're looking to February with another bill, another crack at this, Matt. So we'll probably be talking to you before then, but we'll talk to you then as well.
Great.
But I appreciate the testimony. Sorry you got stuck in a tunnel. And I apologize to Commissioner Demmel that we're not going to get to him this morning, but we will hear from him in Senate Judiciary. And I urge you to do the same in Judiciary and go over some of their challenges in corrections. And I want to thank John Campbell, Judge Zone, Harry Corsone, for the testimony this morning. It was really helpful to understand your perspective. And nice to see all of you and many of you who worked with over the past and as members of House Judiciary. We always work well together until we get to conference committee.
You had one last, by any, didn't we?
That's why we didn't have one.